address it one at a time, Your Honor. First off with the so for count one, second-degree murder, we would be arguing at this time that the state hasn't presented proof sufficient to establish what is required for this court. Specifically, we're arguing that they're relying on improper inference stacking. So the first case we're citing to is Gustine v. State. It's a Supreme Court of Florida case from 1923. The citation is 97 Southern 207, 1923. It's the case that establishes essentially inference stacking. It's an attempted larceny case, but essentially, the facts are that the defendant was charged with attempted larceny. The defendant did not start the car, though he manipulated wires, and the court ultimately overturned that conviction because if the facts in proof are equally consistent with some other rational conclusion than that of guilt, the evidence is insufficient. And if the evidence leaves it indifferent, which of several hypotheses is true, or merely establishes some finite probability in favor of one hypothesis rather than another, such evidence cannot amount to proof, however great the probability may be. And so, essentially, this is an old case, but this case was expressly upheld still, even after the change in the JOA arguments by Garcia v. State, and that's going to be the case 373 Southern 3rd 1213. That's the Florida 3rd District Court of Appeal from 2023, and they specifically do a whole analysis on whether this is still good law, and they explicitly find that Gustine's legal principles prohibiting a conviction based on the pyramiding of inferences remains valid even after the Bush opinion that eliminated the special standard for JOAs. I would direct your attention to page 27. That's essentially kind of where the analysis holds that, and also the analysis on Gustine still being good law. And that's based upon them finding that the sister courts are still upholding it, as well as the use of the axiom of sub silentio. Basically, Florida Supreme Court does not overrule itself silently, they do it expressly. And it's actually important to note that in Garcia v. State, the 3rd District Court of Appeal certified this question, like, is Gustine still good law? They certified it as a matter of great public importance to the Supreme Court, but the Supreme Court ultimately denied review of that case, and it was established and stayed that same way. So, they go on to basically say circumstantial evidence is proof of certain facts, in circumstances from which the prior fact may infer the ultimate facts in dispute existed or did not exist. But I think our concern here is that there's not enough evidence in our case to elevate the disappearance date to an established fact beyond reasonable doubt. So there is this sort of subset of case law in the inference stacking, which basically implies that certain facts, if there's not another reasonable hypothesis, can become established facts. But the issue really for this case is that this is known as what's called the Volcker exception. Essentially that an inference may be admissible into evidence, and it can be the cornerstone of other additional inference stacking if it's to that degree where it's that fact has been established to a reasonable doubt. Interesting to note, though, is they do a whole analysis on this exception. It's only been adopted by the 1st and 2nd DCAs here in the state of Florida, specifically for criminal cases, and the 3rd DC actually decided not to even adopt it. And it's mostly done in civil cases, but it has been slightly adopted. So, the standard, this Volcker exception, is when no contrary reasonable inference may be indulged, such an inference is elevated for the purpose of further inference. We would be arguing that no evidence actually exists to elevate any of the facts established here by the state so that this inference stacking can occur. Garcia is a very on-point case, very similar, alleged homicide, no body was found, similar facts. There's these allegations of fraud in this case, but that's about a check fraud, but still very much on point. And they really start focusing on the fact that there's this date after which nobody hears from the alleged victim within Garcia's case. And that's very similar here. They note in Garcia, which is these facts are similar, that, basically no body's ever recovered, there's no exact time of death, no crime scene to establish the location, time, cause, or manner of death, no eyewitnesses to the death, no confession. Similar to our cases, there was some evidence introduced through statements by Mr. Davis to the police that there was some sort of Italian dinner plans being made. There were some text messages about that, as well as text messages which show that there was maybe communication after the time frame the state is attempting to show that Mr. Schmalbach disappeared or something occurred to him. We've heard evidence that the text messages were slightly different, space, period, space, but even within those text messages submitted into evidence by the state from June of 2023, a month before the alleged disappearance, you see that there's times where Mr. Schmalbach doesn't use that space, period, space, even though, there's this whole line of questioning and evidence suggesting that he's very consistent with his punctuation, even though we see the inconsistencies within the evidence admitted into evidence. And again, at this time, the 6th DCA hasn't adopted this. This is only the 1st and 2nd, and some jurisdictions haven't done this. Specifically, the 3rd hasn't adopted it. So we would argue that even if the court thought that this rose to that level of beyond a reasonable doubt at the time of the disappearance, this court would have to adopt this standard by one of the other courts. Otherwise, it would just be another inference upon which they would have to stack other inferences. So, going further into it, the court also found in Garcia that the jury could not reach the conclusion with inference stacking that the death of the victim was caused by criminal acts the defendant in Garcia could because of the pyramiding off of the foundation of the victim's death on a particular date at a particular time. An impermissible pyramiding of inferences occurs where at least 2 inferences in regard to the existence of a criminal act must be drawn from the evidence and then stacked to prove the crime charged. And in that scenario, it said that the evidence lacks the conclusive nature to support a conviction. Basically the same language that they're pulling from Gustine after they found that it's still good law, even after that change in 2021. Again, they also note that there's a difference between inference stacking and putting the pieces of a puzzle together, suggesting that, in some cases, defense counsel might argue that, we're arguing it's inference, but in this case, the state was trying to argue that they're putting the pieces of a puzzle together. We would argue that the state hasn't put the pieces of a puzzle together. Essentially, they bought a puzzle from Goodwill. Doesn't come with all the pieces, Chief Judge. In Garcia, the DCA found that the puzzle the state argued for was missing significant pieces of evidence that required the jury to resort to sheer conjecture and speculation to fill in major gaps. Again, they cite to certain missing items: no established time of death, no crime scene to establish location, cause, or manner, no weapon or eyewitnesses, no confession. Despite missing evidence, the state wanted the jury to fill in the missing evidence from the chronological inferences from the circumstantial evidence which was being presented to the court and the jury, which is essentially what we've seen here in Mr. Davis's case. Ultimately, several of the facts are very similar to what we've seen here. And actually, they even have a little bit more evidence in this Garcia case than what's been presented to the court. In that case, there was this whole thing about Garcia going on and trying to show that the deceased was still alive, driving the car, making ATM withdrawals. We don't really have some of that evidence similar to this. There is something interesting in the Garcia case, which I find very distinguishing, is that they did luminol testing in the vehicle, and they found a hammer outlined by luminol in the interior of the car. And then they speculated that they used the car to discard of the hammer, also a purse that was outlined by the luminol, and possibly a body. We didn't really see that. They just had some generic, like, oh, there's some stains, nothing like the luminol, which would give maybe a presumptive positive that there's blood or something evidence there. They also go on to elicit that, the car was still present. It made it seem like he was still present, things like that, none of which is here in this case. They talk about in this case that the cell phone continued to have activity for several days after the incident, but ultimately, there's been some suggestion of that, but no actual proofs, just another inference. So ultimately, they overturned that conviction for the second-degree murder and reversed and remanded for the JOA to be entered because it was just a lot of inference stacking without that foundational base that was necessary. I've also cited here Ferris v. State, which cites two. So Ferris v. State is 2025 Florida Appellate Lexus 2544, Florida 4th DCA 2025. That cites to O'Flaherty Lewis v. State 230 Southern 3rd 15, Florida 4th DCA 2017. And it does have the notation cleaned up, but it's the 4th DCA cleaning it up, so I'll let it be what that is. But they do make a mention, direct evidence of intent is rare, and intent is usually proven through inference. Thus, they're going to have to establish, besides through an inference, that there is some sort of depraved mind, mens rea, that's required for a second degree, and we don't believe that's evident here unless they do these impermissible inference stackings. Especially with the idea that from the 4th DCA that intent is usually proven through inference. And again, the crime of second-degree murder, however, requires the more serious mens rea, which I was mentioning about the unlawful killing of a human being when perpetrated by an act imminently dangerous to another and evincing a depraved mind regardless of human life, although without any premeditated design to affect the death of any particular individual. A lot of the cases on that point, it's usually like a stabbing. Well, the act of stabbing itself is of the depraved mind. Oh, there's a shooting, the gun was very close to the head. That would show that depraved mind. We don't have anything of that here, Your Honor, so we would argue that it's all impermissible inference stacking. We'd also point out to Light v. State, essentially proving that the defendant's intent or state of mind, which is critical for second-degree murder, can be particularly challenging without a body or clear evidence of the circumstances of the case, of the death. And in that case, the court noted that second-degree murder typically involves ill will, hatred, spite, or evil intent, which can be shown circumstantially, but again, we would be arguing that it's all related to the inference stacking. Now, going on to the count 2, tampering. The tampering statute outlines is unlawful for any person knowing that a criminal trial, proceeding, or investigation by a duly constituted prosecuting authority, law enforcement agency, grand jury, or legislative committee of the state is pending or is about to be instituted. That's 918.13 Florida statute. Specifically, A states alter, destroy, conceal, or remove any record, document, or other item with a purpose to impair its verity or availability in such proceeding or investigation. I'll actually draw the court's attention to 918.13 subsection 1A, where it specifically states alter, destroy, conceal, or remove any record, document, or other item. It's very specific language. We would actually be objecting to count 2 in their jury instructions for the state. I noticed it this morning, just these arguments, we'll go to that later when we have our charging conference, but they actually included a broadening of that language to include remove any record, document, or thing. An item and a thing are very different, and we would be arguing that they're essentially broadening it. We would be just relying on basic statutory interpretation. Basic rules of that, law should be given its plain meaning. If it says something very particular, it means that very particular thing. In criminal law, we have the expression expressio unius est exclusio alteris, the rule that there's a term of limitation. Anything not included must be excluded. So when they're saying a thing, we would be arguing that an item and a thing are different, and we would even argue that an item is not a cadaver or body, if that's what they're suggesting was actually tampered with in this case. One of the other statutory interpretations is that statute should be interpreted so as to be harmonious with other laws. And there are other Florida laws dealing with the improper disposal of a corpse or a cadaver. That's 406.11, 406.12. For instance, that gives the requirements for disposition of human remains, specifically that when any person dies in the state of criminal violence, it's to be reported to the medical examiner. And then 406.12 duty to report, and prohibited acts. So we would be arguing that this statute is not in harmony with the other statutes, so we would be asking for a judgment of acquittal on that as well. And then lastly, counts 3 through 10, criminal use of personal identification of the deceased. We're going to argue essentially inference stacking as well. There's been no evidence introduced that Mr. Davis did not have the permission of Mr. Schmalbach to use the credit cards that he was alleged to be using, or has been using, sorry. Specifically the statute, under which he's been charged, 8A. So 817.5688A Florida statutes, any person who willfully and fraudulently uses or possesses with intent to fraudulently use personal identification information concerning a deceased individual or dissolved business entity commits the offense of fraudulent use or possession with intent to use personal identification information of a deceased individual. Our focus is really on the who willfully and fraudulently uses. Willfully means intentionally, knowingly, and purposely, while fraudulently means purposely or intentionally suppressing the truth or perpetuating a deception. Again, even the state's own evidence submitted into trial, such as the Discover records, they point that there was all these payments after 7/19, they were paid by the card, they were paid by the Apple Watch, but we also see those exact same payments before 7/19, whenever Mr. Schmalbach was still answering calls and things like that before his reported disappearance. And that's what I'm going to draw your attention to Tinker v. State, and they just go into an analysis on willfully and fraudulently, and specifically as to a deceased individual. That one's more about property fraud, things like that, but it's directly on point with this because it is an analysis of this particular statute. We also heard from, the witness from the Annalise Theresa anesthetic medicine place. That's very common. It's not uncommon for spouses and partners to use significant others' payment methods. And we heard from, at least one or two witnesses, specifically at least Ms. Gleason, someone who actually knew about the relationship between Mr. Davis and Mr. Schmalbach. Now this was a relationship unlike any that she had seen Barry have in the past. So we would be arguing that essentially that kind of shows this continued permission, and there would also have to be, the inference that he was using it fraudulently, but also the inference that maybe Mr. Davis even knew that there was Mr. Schmalbach became deceased, even though there hasn't been really a showing of direct evidence. Again, it would just be an inference. So with all of that, we would just be arguing for a judgment of acquittal on all the charges at this time, Your Honor.
State response?
Absolutely. If I may approach, Judge, I'm going to hand the court what's previously, or what's going to be identified as Crane versus State, 894 Southern 2nd, 59, Supreme Court of Florida decision out of 2004. Myers versus State, which is a Supreme Court decision out of 1997, cited at 704 Southern 2nd, 1368. And Sochor versus State, which is cited at 619 Southern 2nd, 285. 1993. Court will note those are a little bit more recent than the 1923 case the defense counsel cited. Judge, despite the inability of authorities to find the victim's body in this particular case, there is competent, substantial evidence to establish that Mr. Schmalbach is in fact dead and that Christopher Davis is in fact the one who killed him. Corpus delicti in this particular case, Judge, can be proven circumstantially, even without evidence of the discovery of the victim's body. We've established the corpus delicti based evidence of a 58-year-old victim's character, traits, habits, and relationships which negates theories of suicide, natural death, accidental death, justifiable or excusable homicide, or continuing life in absentia. Based upon the totality of these circumstances, Judge, this constitutes substantial competent evidence from which the jury could reasonably have excluded all inferences other than the fact that Mr. Schmalbach is dead and that Christopher Davis killed him. Defense counsel wants to go ahead and allege that we have impermissible inferences and stacking. But in this particular case, Judge, the case law specifically cited by the state with regards to Myers and Crane and Stoshore, specifically, the state must establish the fact of death in this particular case and that the criminal agency or another as the cause thereof and the identity of the deceased person. And that is Crane versus State, 894, Southern 2nd, 59, 2004, citing Myers versus State at 704, Southern 2nd, 1368, which is that Florida Supreme Court 1997 decision. Now, regarding the second element of criminal agency of another, the proof need not even show that the defendant is the one who committed the crime. What we need to establish, Judge, is the fact that the victim was in fact, what we have in fact established is that the victim was reported missing on the 23rd of July, 2023 by Mr. Christopher Davis at the behest of his friend, Mr. Miguel Blanco, after not having seen or heard from him since he left Cruisers that night, which would have been on the 19th of July, 2023. Family, friends, neighbors, and colleagues stated that it was not unusual for him not to contact them. They stated that it was unusual for him not to call, text, or email, even if he planned to be gone or when he was to return. Most of Mr. Schmalbach's belongings, including his identifications, were still at his residence. The victim's family and friends also reported him missing on or about that same time after not hearing from him. Mr. Schmalbach has not been seen or heard from by any of his friends, his family, acquaintances, and or co-workers since his disappearance. The facts surrounding his disappearance indicate that such an absence without contacting family or friends are out of character for him, and the fact that his belongings, his medications, his identifications, his valuables, as well as his vehicle were left at the residence indicates that the absence was not of his own volition. And in addition, Judge, the continued absence of Mr. Schmalbach, along with these facts, indicate that a death resulted from the criminal agency of another. In addition to Mr. Schmalbach's body never having been found, we offered the following circumstantial evidence. We offered that there was in fact an argument. There was a struggle in the condo. There was a removal. There was relationships with his family, friends, neighbors, and colleagues that have not been acknowledged by anyone and responded to by anyone. There was no expression of any desire or intent to leave any of his family, friends, or neighbors by Mr. Schmalbach. He was looking in fact forward to work and spending time with his friends and family up in Chicago. He always let someone know when he was going, when he was coming back. His wallet was left behind, containing his identification, his credit cards. And not only was that only seen on the 22nd, Judge, but later it was disposed of and recovered on the 28th. His watch was also left behind. You heard the fact that he walked and wore that on a regular basis. He left his passport. He left his Jeep, which was his business. His safe and his contents were also left behind. None of his things were missing from his room. His phone records of his last text and call were July 19th, 2023. Cadaver dogs alerted to the back of Mr. Schmalbach's Jeep. The lengths of which Mr. Davis undertook to cover up his deeds with the texts, the credit card usage, and the changing of the door locks, we have introduced sufficient circumstantial evidence to prove that, in fact, the corpus delicti of a homicide has, in fact, been established, Judge. The standard of review is asking simply whether the state presented competent, substantial evidence to support the verdict, Judge. Should be used in all cases when the sufficiency of the evidence is analyzed, even when the conviction is wholly based upon circumstantial evidence. And if I may approach, Judge, I'd like to provide a case to the court. It's cited at Bush v. State, 295, Southern 3rd, 179, 2020. Once again, another Supreme Court decision out of the state of Florida. In that case, Judge, the court cited that the court must view the evidence in light most favorable to the state. Maintaining this perspective, asked whether a rational trier of fact could have found the existence of elements of the crime beyond a reasonable doubt, whether there is substantial competent evidence to support the verdict and the judgment, substantial evidence as such, relevant evidence as a reasonable mind would accept as adequate to support a conclusion, and instructing the evidence is competent if it is sufficiently relevant and material. This standard should now be used in all cases where the sufficiency of the evidence is analyzed. Judge, based upon all of the facts and circumstances the state has provided to this specific court, this evidence that we have laid out over the past 3 days alone is sufficient to sustain a conviction for second-degree murder. As it relates to the Sochor case, Judge, I would specifically point out in that particular case, the court found that evidence that a victim was last seen screaming for help with the defendant on top of her, and that it was uncharacteristic for her not to come home, and that none of her belongings were missing from her apartment was sufficient to establish corpus delicti for a murder, although the victim's body was never found. And they even went so far as to say, in proving that the corpus was sufficient, the circumstantial evidence is sufficient, and proof beyond a reasonable doubt wasn't even necessary in that particular case. In that case, Judge, the facts were such that the victim disappeared New Year's Eve, not been seen from or heard from that night. It was uncharacteristic for her not to come home. She had a good relationship with her family and her boyfriend and kept in touch. None of her belongings were missing from her apartment. There was information regarding the victim that she was screaming for help with his brother on top of her. They found that was sufficient evidence that the victim was in fact dead and that her death was due to the criminal agency of another. And Sochor piggybacks more or less, Judge, off of the Crane decision. In the Crane decision, Judge, the evidence there was sufficient to establish corpus for a murder. And in that particular case, Judge, they found that in addition to an abrupt and permanent disappearance of a young child supporting the inference that the person was dead, there was evidence that she was last seen alive in the presence of the defendant, that her blood was found on his boxer shorts, and that scratch marks were consistent with fingernails that were found on his body. And although independently not determined, they noted that the defendant oddly targeted bleaching of his bathroom in the middle of the night, along with his unusual behavior the next morning, supporting conclusion that the defendant's actions with the girl the previous evening was unlawful and resulted in her death. They concluded that the totality of the circumstances constitutes substantial competent evidence from which the jury could reasonably have excluded all inferences other than the fact that she was dead and the fact that the defendant killed her. Based upon all that, Judge, we've established beyond the exclusion of every reasonable doubt, even at the bare minimum standard at first JOA, that all inferences are drawn in favor of this, should be drawn in favor of the state. We've established second-degree murder. Now, with regards to tampering with evidence, Judge, we've clearly established that. We're not saying that he got rid of the body and that was the tampering of evidence. What we're suggesting, Judge, is the fact that he got rid of the wallet, and not only that, but he also got rid of the pickaxe and the shovel. Those were items he knew that there was going to be a investigation, that there was going to be a prosecution, so he got rid of those particular items. Now, as it relates to the fraudulent use of personal identification information, you have an abundance of information with regards to the use, the videos, and all of the records, the bank records, the photographs, the receipts of all these various places in which Mr. Davis decided to help himself to Mr. Schmalbach's credit cards, his personal identification information, even the phone calls where he tries to feign the fact that he's in fact Mr. Schmalbach when he was in fact not Mr. Schmalbach. Judge, all that occurred after the fact that Mr. Schmalbach went missing on the 19th of July 2023. And he wants to say he had permission. We suggest that he did not have permission, especially after he killed him and got rid of his body. And based upon that, Judge, the state respectfully requesting the court to deny the motion for judgment of acquittal at this time.
Mr. Reddick, your vote?
Yes, Your Honor, just briefly, if I may. The state cites to Socher v. State, Myers v. State, Crane v. State, all older cases. They point out my case is 1927, but it was expressly upheld by 2023, the most recent case. We would also point out that Crane v. State deals with corpus delicti. Not really relevant, we would argue here, based upon the inference. They specifically, in the case notes here, Myers talk about corpus delicti in a homicide case, state must establish fact of death, criminal agency of another, an identity of the deceased person, and more importantly, that typically corpus delicti deals with proving this element before the defendant's own confession is introduced into the record. You don't even have that, Judge. Which actually goes back to the arguments we made about Garcia. There's a general lacking of this solid evidence, and it's all inferences that the jury would have to make and impermissibly stack to get to where they could, make a determination here, Your Honor. We talk about Socher v. State here. That's the case cited to evidence that victim was last seen screaming for help with the defendant on top of her. We don't have any of that. That it was uncharacteristic for her not to come home, and that none of her belongings were missing. If the court, looks at Garcia, they do even find that, there is enough circumstantial evidence in that case, we'll admit that, in Garcia, that essentially, a lack of communication, and a showing of constant communication before could be enough to establish that inference. But what our concern is that in that case, they had to essentially, the court had to show that that first inference of the date of the death of the victim in Garcia was in fact the foundation upon which other inferences could be built off of, and as a result, only the first and second districts have done that. 6th district has not, and other districts have not, the 4th and 3rd included. So we would be arguing that this court would have to find that that fact was established beyond a reasonable doubt to allow the inference stacking of everything else. They talk about, there are scratches in this case for Mr. Davis. That's been, explained by, there was suggestions of cat scratching. They want to infer, again, that it was from these bramble bushes or something out in the Pokies of Hendry County, essentially. Glades County, I believe. But, we talk about cat scratches, but they're so anonymous, synonymous with cats. Talk about oldies and, as a goodie, you got Ted Nugent's cat scratch fever. Everybody knows about cat scratches. It's a thing. So again, there's these reasonable inferences that can be inferred, and nothing's been established beyond a reasonable doubt to start stacking these inferences. So we would just argue for the judgment of acquittal at this time, Your Honor.
Case law, and I reviewed these cases actually prior to the motion, and I reviewed the state's cases as well as the defense cases. I've also reviewed all applicable statutes and considered the testimony and evidence presented thus far in the trial. I'm going to deny the motion